Okay, so now we are starting. The live stream has begun. Good evening, audience. Welcome to another enlightening session organized by Just Corpus. I'm your host, Akshar Aditya, and I'm absolutely thrilled to be here with you tonight. Before we begin, let me introduce you to our esteemed guest speaker, Miss Manasi Bhushan ma'am. Ma'am is a graduate of Government Law College, Mumbai, and a topper of Mumbai University. She holds a B.L.S. LL.B degree from GLC Mumbai, PG Diploma in Human Rights Law from NLSIU Bangalore, and Diploma in Cyber Law from Asian School of Cyber Law. While at GLC, she was awarded Yashwant Dalal Cup, Nivedita Nathany Memorial Award, Chief Justice M.C. Chagla Memorial Award and Scholarship twice, and Godrej Foundation Scholarship. She was the General Secretary of the Legal Aid Committee and the founding member of ADR Cell in her college. Currently, she is a practicing advocate in Delhi High Court and does civil, criminal, matrimonial, check bouncing, service, and arbitration matters. Along with that, she also delivers guest lectures in various law colleges. To our esteemed guest, thank you for joining us. We are honored to have you here with us tonight. Now, before we dive into our topic, let me give our viewers a brief overview of the organizer behind tonight's session. This corpus is a body of legal professionals who have come together to bring various aspects of chains of law under a single umbrella. This corpus is an edtech platform established in 2020 and has a wide reach of 600,000 clicks per month on an average basis on its website. The inspiration was derived from the ever growing need of law students. Just Corpus is also incorporated an interdisciplinary journal as its subsidiary named the Just Corpus Law Journal. Now, on to the main event. This evening, our esteemed guest will be shedding light on the topic of cruelty, the evolving law, and its judgments. Ma'am, the virtual stage is yours.
Thank you, Akshar, and thank you, Just Corpus, for having me on board. It's a pleasure to associate with this organization once again and speak on a very important issue, which is cruelty, and discuss its evolution, what are the laws pertaining to it, as well as the landmark judgments or, say, the instances as to when it amounts to cruelty, be it from the perspective of, say, a law student who's currently studying, or say from a perspective of a lawyer who's currently practicing, or say from a perspective of a citizen who probably might face the wrath of this law or might be a victim and would want to seek remedy under this law. So firstly, we see what is cruelty. Cruelty we find mentioned in two different legislations. Primarily, one is the Indian Penal Code, which is now the Bharatiya Nyaya Sanhita. So section 498A of the IPC is now section 85 and 86 of the B.L.S, which is Bharatiya Nyaya Sanhita, which are the new criminal laws which are being enforced since 1st July 2024. And the second reference where we find of cruelty is the Hindu Marriage Act under the grounds for seeking divorce, which is under section 13(1)(a)(1). So 13(1), numeric I, small capital I, and A of the Hindu Marriage Act. So if we talk about IPC, Indian Penal Code, initially there was just section 498 and then thereafter 499. There was never such section of 498A. So this 498A came as a second Criminal Amendment Act in 1983. And it was introduced because there were increasing number of deaths due to dowry. Now, the concept of dowry is basically a demand of, say, a certain valuable property, money, or say some asset by the husband or the relatives from the wife or the wife's relatives, parents, whatever the case may be. There was an act called Dowry Prohibition Act in 1961, which was already penalizing such taking of dowry, which is under section 3 and 4 of that act. But the cruelty which was cast on the wife, especially, who was basically a married woman to her husband, was not being remedied under the Dowry Prohibition Act. And such acts, because of which the woman would, say, commit suicide, would cause herself a grievous hurt, or would endanger her life, was not specifically being remedied under that act. And therefore, there was a need to curb the increasing number of deaths, say, because of the dowry demand. Now, dowry, as I said, is not just, say, money, can be property also, or is not just property, can be money as well. So that was the object. Now, if we see section 498A of IPC and if we see section 85 and 86 of B.L.S, we will find they are verbatim same. 85 is the section and 86 is the explanation, whereas it was consolidated in our IPC earlier. So it says basically a husband or a relative of a husband. Now we need to understand who can be a husband and who can be the relatives. And then it says of a married woman. So which means a girl who's unmarried, let us say who's engaged and who's not yet married, and because of certain reasons, say because of illegal unlawful demands of dowry, the marriage is called off. Then in that case, that woman is not yet married and cannot seek recourse under 498A. Would of course would seek recourse under Dowry Prohibition Act or other. May I continue?
Yes, ma'am. Yes, ma'am. Of course.
Or other provisions of, say, the Indian Penal Code or now the B.L.S. And then it provides, it says that whoever being the husband or relative of the husband of a woman subjects such woman to cruelty. The word is used over here, cruelty, shall be punished with imprisonment of a term which may extend to 3 years as well as liable to fine. And then it says the explanation as to what is cruelty. So it is differentiated in two parts. Part A is that any willful conduct which is of such nature that is likely to drive the woman to commit suicide, which is not necessary that she will commit suicide, likely to drive her, that there is high possibility that the conduct is as such that that woman might commit suicide, one. Second is likely that woman might cause grievous injury to herself. Now, grievous injury again is defined under B.L.S or IPC, which is, say, it is not a simple injury. For instance, say, damaging of impairment of hearing, say, loss of teeth or tooth, say, loss of eye or eyes, all of that is grievous hurt. Danger to life, limb or health. Now, danger to health again is a wide ambit. It's not just, can be danger to health can be, say, through depression or say through anxiety, say through a panic attack. So it not necessarily be that a person has to die, whether physical or mental. So cruelty can be of two types. One is physical beating, say simple hurt, grievous hurt, whatever the case may be, as well as mental, affecting her mental well-being. And the second clause which we talk about, this first one is talking about physical as well as mental cruelty. With an intent, done with an intent that the woman commits suicide, causes herself grave injury or endangers her life or limb. Endangers her life or limb means cuts her arteries, cuts the hand, tries to commit suicide, tries to hang. So all of that. The second part is interesting. It says harassment of a woman. When such harassment is with a view to coerce her or any person related to her. Any person related to her can be parents, can be brothers, sisters, siblings, some close friend. Anybody who's related to her. Now this related also has been interpreted by way of various judgments. To meet any unlawful demand for any property or valuable security or is an account of failure by her or any person related to her to meet such demand. So basically first ingredient is harassment, which is being done, not just harassment, done with an intent to deliver certain property which is unlawful, which is, say, demand for dowry, demand for money, demand for valuable security. Now, what amounts to cruelty is a simple Oxford dictionary which vaguely tells that cruelty, is that cruelty or is there specific threshold under 498A for it to amount under the offense of 498A? Is that so? So Supreme Court has said cruelty can be of a nature that it is likely to drive women to commit suicide, grave injury. Simpliciter cruelty, simpliciter actions which are cruel in nature. Suppose a mother-in-law taunts the daughter-in-law, stating you do not cook well, you don't know how to cook, your mother didn't teach you how to cook. That in itself will not be cruelty under 498A of IPC, which is section 85 and 86 of B.L.S. Will not be so, even though one can say this is a cruel statement made by the family members or relatives of the husband, but it is not done with an intent to seek certain delivery of, say, unlawful demand of money, valuable property. And it is also not of such nature that it would lead that woman to commit, say, suicide or commit grave injury or danger to her life or limb. Another thing, harassment simpliciter, as I said, a cruel statement or cruel actions or harassment simpliciter is not cruelty. Harassment has to be coupled with an intent, either for woman to commit suicide, grievous hurt, or danger to life limb, or coupled with unlawful demand for property. Simpliciter abuse, say a slap by a husband to the wife, for 498A IPC or 8586 of B.L.S, it is not a sufficient threshold. One will have to show that it was done with the intent. There was an ulterior intent. One, to demand money, valuable security, dowry, or as such that woman would commit suicide, cause grievous hurt, or endanger her life. So who can be a complainant? The question comes over here. Can only wife be a complainant, or her family members can also be a complainant? Let us assume partners living in live-in relationship. Can that woman who's living in live-in relationship be also a complainant? Let us assume husband staying with a mistress. Not a husband, I'm sorry. A man staying with a mistress. Can that mistress come under 498A? So, who can be a complainant? Complainant can be a mistress and will be deemed as a wife. This is being stated by Andhra Pradesh High Court. And at the same time, we have a conflicting judgment of Maharashtra High Court, of Jharkhand High Court, and of Odisha High Court. So there are judgments: Madhuri versus State of MP, Vasantbhai Patel versus State of Maharashtra, Jogeshwar Rao versus State of Jharkhand, Atmaram versus State of Chhattisgarh. Over here, what it says a mistress is not equivalent to the wife. And therefore, since she is not a wife, she is not a married woman, therefore she cannot prosecute under 498A. She may have other remedies, but not under 498A. And this complaint is to be made by the aggrieved person only. It cannot be made by the family members of the wife. It cannot be made by a friend of that wife, of that married woman. It has to be made by the aggrieved person. Now, this is being said by the Guwahati High Court. Of course, if we see that there is some conflicting judgment, say by some another court, High Court, in that state, that judgment could prevail. Now, for how long can a wife file such a complaint? Or suppose the marital relationship was going all hunky-dory and suddenly, or say over a period of time, it has deteriorated. And now wife decides to file cases against the husband. And then she puts in all the instances against the husband and the relatives. Say 20 years ago this had happened, 25 years ago this had happened, 10 years ago this had happened. So the limitation period for filing 498A IPC or 8586 B.L.S is 3 years. This is being given by the Rajasthan High Court. Again, as I said, if there is another High Court giving a conflicting judgment, then in that state, that limitation period would apply. Now, where can this complaint be filed? What is the jurisdiction where this complaint can be filed? There is a discord between the husband and wife. Wife finally goes back to her parental home. And from there, she's in, say, let's say, Bombay and Delhi. So she was staying in Bombay, now Mumbai, and then she comes back to Delhi. Now in Delhi, she wants to file this 498A complaint, whereas always all the alleged instances took place in Mumbai. Then what will happen? Where will she file complaint? She does not want to go to Mumbai. She files a complaint in Delhi Magistrates Court stating that I am being forced to come back to my parental home because of all the harassment, cruelty which was met to me in Mumbai, in my matrimonial home. Will the court in Delhi entertain this complaint? Did any cause of action, did any offense took place in Delhi? The answer to that is no, it did not. So therefore, the court will not take cognizance in the place where the offense has not taken place. So this is again given by Punjab and Haryana High Court in one of the judgments, Tasram Singh versus Amrit Kaur. But let us assume a part of the offense took place in the parental home and part of it took place in the matrimonial home. For instance, in Delhi, the husband came back to take her, but there was again a tiff. Again, a taunt was made by the husband. Again, a demand for, say, dowry was made before the parents at the parental home. Then, yes, wife can institute. Wife can lodge a FIR under 498 IPC. Now it will be 8586 of B.L.S, Bharatiya Nyaya Sanhita, and that will be a valid jurisdiction. Now, this is said by the Allahabad High Court in Vijay Ratan Sharma versus State of Uttar Pradesh. Now, let us understand what if the marriage in itself was illegal. It was a void marriage. It was an invalid marriage. And that marriage has been contested by the husband, say in some another court, in another case. The husband is saying this is a void ab initio marriage. This is a void marriage. It is an invalid marriage. And at the same time, wife had filed case against the husband under 85-86 of B.L.S. 498 of IPC. And let us assume the husband wins the case. Husband got a favorable decree that this marriage in itself was a null and void marriage. It is not a valid marriage. Then will 498A conviction take place, or will that case itself go for a toss? It will not be considered as a appropriate case, because obviously it has to be by a married woman. She is not a married woman. So again, there are conflicting judgments. The Karnataka High Court says that even if it is declared that the marriage is null and void, it will be deemed that parties were married at the time when the offense is alleged, instances are alleged, and therefore 498A trial will continue even though marriage is declared as void by, say, another court, say another state, doesn't matter. But the other courts, which is Odisha, Chhattisgarh, as well as Kerala High Court, all of them have said that the moment it is declared that the marriage in itself is invalid, 498 IPC 85-86 of B.L.S. will not be applicable, because the basic proposition for the wife to be married is missing, and therefore 498A. Even though, let us assume, husband has won the case that it was a null and void marriage later, and 498A was instituted earlier, then also 85-86 B.L.S. will not sustain, criminal law will not sustain, because of the civil decree that husband has got regarding the validity of marriage. Now, let us understand some instances. What are the instances of cruelty? So, a wife asking husband to return back her Stridhan. What is Stridhan? All the gifts given to a woman at the time of marriage and after marriage becomes her property. It is Stridhan. It is woman's property. So that's why it's called Stridhan. She again and again asked husband and husband's relatives that you give me back, mother-in-law, that I have kept my jewelry with you. Please return it back to me. Husband or the relatives deny giving it back, refuse giving it back. It will amount to cruelty. Now, husband doubts. Another instances, a husband, now all these whatever I'm saying are on the basis of some judgments by some high courts, either Supreme Court or various high courts. Now, husband doubts a wife that she must have eloped with somebody else for some particular time, because she was not with me at that time. I was on a business trip. She was not here, and she had eloped somewhere else with somebody. And because of that suspicion, husband rarely talks to the wife. Now, in this case, wife files a case against the husband that this amounts to cruelty. I am in such mental state, it is affecting my mental well-being to such an extent that I have undergone, say, grievous hurt, which is a good ground for going under 498A. It is qualifying 498A clause 1. But then the court says this is not cruelty. This is natural. It can happen. So it will not amount to cruelty even if husband is rarely talking to the wife based on a certain suspicion, which is, say, all in his mind, which is never true, but that is his nature. So court does not indulge in this, and had said this was in state of Gujarat versus Gajendra Bhai Amrut Parmar. Now, can, say, if somebody is asking, say, for some money, give me 10,000 rupees. I need it for so and so purpose. Will that asking of monetary amount also amount to demand for dowry and will fall under the ambit of cruelty? The answer is yes. Monetary demands fall under valuable security or property. Now, let us say a false, vexatious, malicious case was filed by the husband against the wife, only to torture the wife. A lot of cases were filed, some execution petitions were filed, Some bailable warrants were issued, some warrants for confiscation of properties were issued based on a lot of litigations and backgrounds, reasons whatsoever. Now, will this amount to cruelty on the wife? Can wife file a 498A against husband? The court has held that yes, it can amount to a cruelty by the husband only if it is proved that the cases filed by the husband were vexatious, malicious, false in nature. Then the false allegation regarding wife cannot conceive a child. Now this allegation is taken by the husband in a divorce case. Says wife cannot bear a child. Now this again would amount to cruelty. It will amount to harassment, as Punjab and Haryana High Court has held in one of the cases. Husband takes away the minor child away from the wife and says, only when you pay me so much amount, I will get back the minor child at home. Till the time you don't bring me money, I am not coming back. And the child also, you don't get to see his face or her face. Now again, this would amount to cruelty. Husband not allowing the wife to go back to her parental home. Says, you have married me, now you are a part of this family, you are not supposed to go back to your parental home. This is our Hindu rituals, this is our marital rituals. So again, this would amount to cruelty. This is held by Rajasthan High Court in Babu Khan versus State of Rajasthan. Now, what about suppose a husband every day keeps on saying that you didn't get enough money, you should have got more money. Why don't you get 10,000 from your family? Why don't you bring 1 lakh from your brother? He's earning so well. That's it. He's just making these comments every day. Now, court has held Supreme Court has held in Bhushan by Ramsang by Chaurasia versus State of Gujarat, AIR 2015 SC 2670. That mere demand for dowry is not cruelty. It is just a demand. Had it been that it was coupled with an intent to harass, with an intent to the wife to commit suicide, with an intent that the wife commits, causes herself grievous injury or endangers her life, then it would amount to 498A cruelty. Otherwise, under 498A, it will not amount to cruelty. So you see that there is a difference in threshold between 498A and when we come to the divorce under section 13 of HMA, we'll find that there is the threshold under 498A is much higher. It has to be coupled with an intent for a woman to commit suicide, for a woman to commit grave injury, for a woman to cause danger to her life or limb, with an intent to ask women to get unlawful demand for dowry or money. Now, what if a wife had filed a police case, a state case under 498A, and there the husband was acquitted? And then again, she filed a private complaint against husband and relatives stating that there is cruelty. So, court holds once husband and relatives are acquitted in a police or state case, it cannot be retried by way of a private complaint. Now, court also understands and has said that usual domestic discord, usual bickering, usual fights, one-time beating by the husband say to the wife is not cruelty. It is usual, just like every relationship can have ups and downs. Similarly, marriage also, usual discord, if it is there, it will not amount to cruelty. Petty quarrel will not amount to cruelty. Manjuram Palita versus State of Assam, 2009, 13 SCC 330. Now, what if husband is every day coming late in the night, fully drunk, cannot understand as to what is there around him, his friends are getting him back to the home. The wife does not agree about it. She is completely against it. Court has held this also is not cruelty till the time he is not abusing you, till the time he is not abusing physically or mentally the wife. That is his lifestyle. He can have a lifestyle of his own, even if it is not suiting you, even if it is against you, even if you have told him not to do it. Still, if he is doing that, that is his lifestyle and that will not amount to cruelty. Mere beating on one occasion, as I said, just like every relationship can have ups and downs, so mere beating once, say in a long span of time, will not amount to cruelty. Once a husband asked money from the wife that please get some money from your brothers, I want to buy a car and I will use that car as a taxi to run this house. Again, court said this will not amount to cruelty. Now, interestingly, once a husband told a wife that you don't enter kitchen because the food that you will cook will ultimately get wasted. I will not eat it, my family will not eat it. We don't like the way you cook. So ultimately, it will waste. It will go in waste. So in order to prevent wastage, please do not enter kitchen. If this statement is being made by the husband, again under 498A, it will not amount to cruelty. So husband can make such a statement. Suppose relatives of the husband are sympathizing with the husband that okay, you can seek demand, you can have demand for dowry, you can demand dowry from wife. There is no difficulty with that. That's the tradition, that's the marital relationship. That is how we have done, we have seen elders doing. So relatives is sympathizing with the husband who is demanding dowry. So Kodam Gangaram versus State of Andhra Pradesh High Court says this is not cruelty. As I said, there might be conflicting judgments of other high courts which would amount this to cruelty. Now, wife said that I almost died because I was not given food for 2 weeks, 3 weeks. I kept on waiting. My husband didn't provide me with food. He locked me up in a room. So all these allegations without any proof. The proof in this case, what wife gave was a mere letter given to the police, complaining about the husband and asking police to punish the husband and his family members. Court said there is no proof, there is no medical record to show that you were actually dying near starvation, you had physical ailments because of no food, malnourishment, nothing. You didn't provide with any proof. There is mere allegation and a mere complaint letter given by you to the police. So therefore, it will not amount to cruelty. You cannot prosecute under 498 IPC or 85 and 86 of PNS. This is again Gujarat High Court, Kantilal Marji Ponder versus State of Gujarat. So these are some instances as we understand as to what is cruelty and what is not cruelty. Now, what type of offense is this? What is the nature of this offense? This offense is a cognizable and a non-bailable offense. Cognizable means the police can come and arrest the accused persons without having a warrant to arrest issued by a magistrate. So the moment a wife registers a complaint, police can go to the house of accused persons, husband and relatives can arrest them. And it is a non-bailable offense. A bail is not a matter of right in this offense. So all the relatives and husband have to rush to the court to seek either anticipatory bail, or once the charge sheet is filed, then a regular bail. So then what happened? As I said, there was this law made with an intent to provide justice to wives, to married women who were aggrieved by such ill treatment of the husband and relatives, but that was starting to getting misused. There was initiation, a stage came when it was so highly misused that Supreme Court had to intervene and come out with the judgment, landmark judgment, Arnesh Kumar versus State of Bihar. 2014 SCC Online SC 532. In this judgment, Supreme Court lays down a lot of guidelines and tells the police that 498A offense, you have to issue section 41A notice prior to the arrest. What is section 41A notice? Requesting, not requesting, directing the accused that you have to come and cooperate in the investigation. You are being alleged with so and so allegations by your wife. Please come and cooperate in the investigation. Provide me with the necessary documents or information. The husband has to abide to this notice. Should ideally go to the police station, either himself, if he's been accompanied by a lawyer, it is permissible, and then answers to all the queries as to what the police officer asks. If the accused, be it husband or relatives, don't adhere to this notice, then police can obviously go and arrest these persons. But without issuance of 41A notice, police cannot arrest. Second, if the police is not arresting, it has to give reasons to the magistrate within 2 weeks and stating as to send its report as to why are the accused persons not being arrested. Magistrate has to record the reasons for arrest of the accused persons, and then the arrest will take place. If all of this procedure is not followed either by magistrate or by police, then departmental inquiry against the magistrate or police, or the contempt of court can be issued against the police officer. So this helped the society. A lot of husbands were committing suicide because of such misuse that court had to intervene, come up with this judgment and tell the police, though it is the work of the legislature to make the law. But in this case, Supreme Court suo moto had to come up and say so, that you can't go ahead and arrest just like that. There needs to be a reasonable ground as to why are you arresting. There needs to be intervention of the magistrate. You should give opportunity to the husband to come and answer to the questions. And then only if there is a reason, if there is a genuine case, if there is a reason for custodial interrogation, which might not be the case every time, then only you arrest the accused persons. And court also opined that it is better to make this offense a compoundable offense. Compoundable means that the parties can compromise among themselves, reach a settlement, and once they have reached the settlement, the offense, the FIR, can get quashed itself. There is no need to file a separate quashing petition before the High Court. So it can get quashed before the magistrate court also, or say before the police as well. This was given by the Allahabad High Court in Madhurima Bhargav versus State of Uttar Pradesh. Now, what if suppose FIR is lodged, accused is there, accused will go and seek bail, depending on which state is he. Suppose in Uttar Pradesh there was a time when anticipatory bail was not permitted, so he could have moved only a regular bail after filing of the charge sheet. Suppose in Delhi we have a concept of say anticipatory bail, so accused can go and file an anticipatory bail also if he apprehends arrest, or say a regular bail after a charge sheet is filed. Now, what else can he do if he feels that in the FIR, in the charge sheet, as such, there is no allegation against me? Can he move a discharge application? So, the answer to this is given by the Supreme Court in Karkashan Kausar versus State of Bihar 2022 6 SEC 599, in which the court said the court should be careful while proceeding against the distant relatives as well as the husband in crimes pertaining to matrimonial dispute and dowry debts. And if there is no allegation made at all in the FIR, in the complaint, then it is better to discharge those persons against whom there is no allegation, because it will ultimately lead to wastage of their time. They will be traumatized, they will be financially burdened, they will undergo such sort of mental stress till the time this case is going on, and nothing fruitful will come out of it. Again, the 3 judges bench of the Supreme Court in state of Karnataka versus L. Munuswamy, the court again said that there should be a ground for presuming that the offense has been committed, and there should not be a ground for presuming that the conviction certainly will be done. So what is the difference? There is a possibility that offense has taken place, or there is beyond doubt, beyond reasonable doubt, that certainly this offense has taken place by these accused persons. So these 2 differences are there. Court should look at the possibility that yes, it is possible that this offense has taken place by these accused persons. That should be considered at the time of discharge, and court should not be thinking that is 100% this offense committed by this accused person. That should not what the court should look at the time of discharge. Again, Neelu Chopra versus Bharti, 2009-10 SEC 184. The Supreme Court said that for lodging a proper complaint, the relevant section and language, what does the complaint do? The complainant goes to a lawyer. Lawyer reiterates the portions of 498A IPC or 8586 of B.L.S, puts it in their complaint, and does not actually mention the specific instances as to when and what had happened. So simply saying that 498A was committed, or say there were instances of beating up for demand of dowry, that would not suffice. There has to be specific allegation. You need to mention the date, you need to mention the specificities of the offences and by each and every accused person. Suppose it is done only by, in reality, by husband. But just to implicate, all the in-laws are also implicated in that complaint. But no mention of what date, what incident, what had happened, how it had happened, who was the witness to such incident is mentioned anywhere against the relatives. So then relatives, of course, can seek discharge. This is the three judges bench telling to the Supreme Court. Suppose a complaint is made against, say, a girlfriend of the husband, or say a concubine of the husband, or say a foster sister of the husband. The Supreme Court has said again, these are not relatives. They cannot come under the category of relatives. And since they are not relatives, 498A or 8586 of B.L.S, 498A of IPC cannot be instituted against them. But the Kerala High Court has said that the second wife of the husband is a relative, and therefore she will come under the ambit of 498A. Interestingly, let us say a case is not even made out against the husband. Then the Karnataka High Court says that automatically it will not be maintainable against the relatives also. Again, this is Karnataka High Court. If another conflicting judgment is there for some other high court, then in that state, that judgment could prevail. Let us say there is a couple, husband and wife. Wife is thinking that he is my husband. Under some, say a twin brother is there, or she had met an accident and she is under some memory loss, or she is under some wrong notion and she feels that the man with whom I am living is a husband. He is not a legally married husband. Or let us say a live-in relationship. Then it is being held by Andhra Pradesh High Court in Corpus City Subbarao versus State of Andhra Pradesh that husband need not be a legally married husband. So even if what I assume an interpretation of this could be also for a live-in relationship partner, then 498A can be initiated and that person can be prosecuted under 498A or 8586 of B.L.S. Again, sister-in-law is not a relative, and since she is not a relative, therefore, she cannot be prosecuted under 498A. In this case, in Ram Sahai Varshney versus State of Uttar Pradesh, what had happened? Sister-in-law had occasionally visited, only once or twice in the matrimonial home because she herself was married to another man. She was the sister of the husband. So court held that she cannot be under the category of relative. She had hardly visited twice back to her parental home, which is the matrimonial home of the wife, and therefore she cannot be a relative. So for quashing, what does the husband do? Suppose a discharge is given, then it is a win for the husband or the relatives. Suppose if discharge is not given, then another option to the accused persons is to go for quashing of the FIR. As I said, discharge is an alternative of quashing. Suppose if discharge is denied, then usually high courts, for quashing one goes to the high court. High courts would also not entertain the quashing petition because the trial court has already found that the accused must be tried and let the outcome by way of a final judgment come, and then only it will be decided whether he is actually convicted or acquitted. So quashing petition usually will not sustain, one might not succeed, but yes, prior to discharge, one can also go for quashing directly before the High Court as soon as the FIR is lodged. So in quashing petition, the Supreme Court says that the factors one should consider while quashing the petition is that the material given by the wife or the married woman, is that correct material? Moreover, the material given by the husband or the relatives, is that of impeccable quality? Can it be rebutted, or if not rebutted? Suppose the material was given by the husband that I have been staying separately from my wife since last 10 years. We had that understanding. It is a long distance marriage. So all the allegations with regard to physical beating cannot be possible, are just concocted stories, nothing else. And he is able to substantiate, say, by his GPS locations of the phone, or say by the letters that they had exchanged, or say by the emails, the WhatsApp conversations, the places on their social media they were uploading of their say work profiles, their work statuses, the places which they were visiting, and it's all clear that they have been living in different cities. In that case, the court says if the material given by the husband is of impeccable quality, it cannot be rebutted. Or if the prosecution did not rebut the material given by the husband, and the trial would result in abuse of process of law, then if the answers to all these questions is yes, then the quashing petition should be allowed and the accused persons should be directly acquitted. As I said, there was a misuse of 498A. That's why Arnesh Kumar judgment had come. Now let me just give you some statistics that there were approximately 93.6% cases which were being charge sheeted in 498A. Imagine, out of 100%, 93.6% cases were being charge sheeted under 498A. And the conviction, which were actually proved that these were the persons who had committed cruelty, were only 15%. Out of 93.6, only 15% people were held as guilty for committing cruelty. Rest all were acquitted. So because of such statistics, Supreme Court took cognizance, came up with Arnesh Kumar judgment. Not just with that, there are times and again when Supreme Court has said that 498A is being misused. So Sushil Kumar Sharma versus Union of India 2005 Supreme Court says that court can only interpret a law, it cannot legislate, it cannot make a new law. So legislature, please look into this provision and please consider the practical realities and make according amendments in it because it is being highly misused. Omkar Nath Mishra versus State of NCT of Delhi, again 2008 Supreme Court says that the provision of 498 IPC should not be used as a device to abuse the husband and the relatives. Now, a landmark judgment on this is Preeti Gupta versus State of Jharkhand. In 2010, again, the citation is 2010 7 SCC 667. Supreme Court over here, the wife had not left anybody possible of the husband. She had in fact impleaded a bedridden father-in-law or almost near to deathbed mother-in-law as the accused person under 498A. So the Supreme Court said that there is gross misuse of 498A. There is a tendency to exaggerate the offense, exaggerate the events, over-implicate the persons who are actually guilty, not just them, but their relatives also, far distinct relatives also are being impleaded. So it is high time that legislature should look into this and make according amends looking at the practical realities of this law. But again, nothing was done. Finally, this year, 2024, when we have B.L.S, we see no change in 498A language and B.L.S language 8586, it is verbatim same. Even this year, Supreme Court in Achin Gupta versus State of Haryana, 2024, SCC online, SC 756. Again, Supreme Court has said 498A, which was earlier IPC, now 85 and 86 of B.L.S. It is being highly misused. Kindly relook into it. We are the court. We can only interpret. We can't legislate. So you are the one who's to legislate. Please relook into it and make according amendments. But as I said, there is no such amendment which is made in B.L.S. Any change in B.L.S. Now there is certain interplay between 498A IPC, which is 85-86 of B.L.S, and dowry death as well as murder. So dowry death would be 306 of IPC, which is 108 of B.L.S, and murder, which I believe is 183 of B.L.S. So there is a distinction. Murder, the threshold of course has to be very high. The intent and knowledge that the act likely to cause grievous hurt, which is likely in ordinary course of nature, results in death, or with the knowledge done and with intent to cause death. That is section 299 and 300 of IPC, which is now 103 of B.L.S. And dowry death is within 7 years if a woman dies and there was a demand for dowry, it will be deemed that that death took place because of such illegal demand for dowry. So 498A, suppose a woman commits suicide, then of course 306 will also be written in the charge sheet, and possibly 302 will also be written in charge sheet. But the Supreme Court again has said that once suppose somebody is acquitted in 306 or 302, it does not mean that it is an automatical acquittal in 498A. The threshold of 302 is much higher. The threshold for 306 is also higher. It does not mean that automatic acquittal will take place for cruelty also, 498 or 8586 of B.L.S. Now, cruelty, this was all under the criminal law, as I said, was having a much higher threshold. Now we'll come to the matrimonial law, which is the Hindu Marriage Act. Now in Hindu Marriage Act, only Hindus who are not reconverted or say who are born as Hindus, who are by birth religious as Hindus, Raja Gopalan versus Rajamma, AIR 1967, Kerala 181, as to what are Hindus under Hindu Marriage Act and who can claim the ground of cruelty under Hindu Marriage Act. So first Hindus, and second and most importantly, under 498 IPC or 8586 of BNS, only husband and relatives were the accused. Wife was never an accused. Wife was always a victim. It was a gender specific offense. Under our Hindu Marriage Act, HMA, it is a gender neutral offense, which means both husband and wife can be victim, which means both husband or wife can be accused. So husband can claim ground as cruelty for divorce under HMA, and whereas he is alleging against the wife, and same goes for the wife. So cruelty in matrimonial cases, usually our matrimonial law is based on a maxim which says that let husband and wife live together, let us save the marriage. That is the primary aim of any matrimonial law if we see. However, if parties can't stay together, cohabit together anymore, it is so difficult for them that it is impossible for them to stay anymore, then divorce is being thought of. So section 13(1)(1)(a) of HMA speaks that any marriage solemnized, whether before or after commencement of this act, on a petition presented either by husband or by wife. So petitioner can be husband or wife, any of the two, be dissolved by decree of divorce on the ground that after solemnization of marriage treated the petitioner with cruelty, which means that petitioner be husband or wife. Any of the two, whichever of the two is filing the petition, can be treated with cruelty. Victim can be male or can be female, doesn't matter. Accused can be male, can be female, doesn't matter. How will determine whether cruelty took place? Section 3 of Indian Evidence Act, which has now become Bharatiya Shakshi Adhiniyam. Over there, again, fact and issue. What are the facts that are alleged? And that facts needs to be proved. Who will prove them? Again, burden to prove is on the petitioner who's alleging, or on the respondent. Whosoever is alleging whatever fact has to prove it. So our principles of with regard to burden of proof and onus of proof will come into picture. And the decree of divorce will be given under section 23 of HMA. Now the court will be satisfied. Now over here, it is not beyond reasonable doubt, which was there in our criminal law in BNS and IPC. Over here, this is a civil law. It is based on preponderance of probabilities that this would have happened. It is not 100% this has happened only. So this would have happened. So yes, it will amount to cruelty. So that's why I was saying the threshold under criminal law is much higher. The threshold under civil law is comparatively lower. Now, what are the types of cruelty under HMA? Let us see that. Cruelty again can be of two types. One is mental cruelty, second is physical cruelty. Mental cruelty with regard to mind, suppose a person is undergoing anxiety, depression, panic attacks, can refer to the medical records, can produce those medical records before the court, or can orally testify before the court that I was unable, I had a severe hair fall. I could not eat food. I could not sleep. I was constrained to taking sleeping pills. These are the prescriptions. These are my doctor reports, medical records. All of that can be produced to show that there was mental cruelty. Physical cruelty, of course, even if there's simple hurt, grievous hurt, whatever types of beatings have taken place, the photographs of those beatings, the medical prescription in order to cure the harm which is done, injury done to the body, or say medicines, all of those can be used to establish that there had been cruelty. Now again, what to some people, some things might be cruel, to some other people, those things might not be cruel. It might be, for instance, say 15 years ago, if somebody, say a husband said to a wife that you are too thin, would have called her a matchstick or some sort of similar word, she would not have minded. But now let us assume the same thing is being said by the husband to the wife because of awareness, because of such talks in the society, she might think that he is body shaming. So that might amount to cruelty here. Now here, there is no intent that this woman would commit suicide, no intent that she would endanger her life, she would cause her grievous hurt to herself. No intent that she get dowry. So 498A or 8586 of BNS would go away. But cruelty under 13(1)A will still sustain. Now, cruelty will depend on the type of the life that the parties are used to. What is their lifestyle? What is their economic and social status? Using of abusive language was common during their conversation, or it was only during the fights, or was it only meant to disrespect the spouse? So that will depend, and court will take into that consideration. And once it makes of a view, it is of the view that this lifestyle was, they were used to calling each other names. They were used to mocking each other even otherwise. So as such, this will not amount to cruelty. Shobha Rani versus Madhukar Reddy. Supreme Court, 1988, 1 SCC 105. But if suppose there is a persistent demand for dowry, time and again and again and again, every day she is being hearing that you didn't get enough money, you are not belonging to our lifestyle, you didn't suffice to my demands, we would have liked if this would have been a lavish wedding. So then it would amount to cruelty in HMA. But as I said, in criminal law, it might not amount to cruelty because the threshold is quite high. Again, as I said, in criminal law, normal wear tear of marriage, one-time beating, normal bickering, all of that, court condones, understand that usual ups and downs can take place in a marital relationship, just like other relationships, and would not necessarily would not necessarily allow the petition filed by the petitioner. Heavy drunkenness, habit of addiction to drugs, all of that court has condoned and has not said upheld that as cruelty. But if such drunkenness or drugs addiction is coupled with violent treatment, then court has said that it is cruelty. Now, mental pain, and how can we understand as to what is mental cruelty? A landmark judgment on that of the Supreme Court is Gurleen Kaur versus Lakhbir Singh, which is citation I'm telling you, Manu DE 0786 of 2016. Over here, lot of human behavior guidelines are being put down. Jealousy, possessiveness, having a sense of ownership on the other side, dissatisfaction regarding the habits of the other person, isolated period of time over the years, staying separately for some time, all of that is not held as mental cruelty. But at the same time, being frustrated, always losing temper, being rude in language, neglecting the marital duties, continuously using abusive language, all of that is held as cruelty, which will amount to mental cruelty. Another instance in this judgment, what it says is that the husband himself had went for sterilization operation without telling the wife, or the wife herself unilaterally went and aborted the child or husband denied having a child and concealed that before the marriage and never wanted to have a child, all of that would also amount to cruelty. Husband or wife unilaterally denied to have sexual intercourse without any sufficient reason, without any incapability, just out of their free will for a considerable period of time, would amount to cruelty. So all of that is given in Gurleen Kaur's judgment, Gurleen Kaur versus Lakhbir Singh. And there are certain instances which would not amount to cruelty. For instance, earning wife not ready to share her salary with the husband and in-laws will not amount to cruelty. It is her money. If she does not want to share it with the husband, it is her choice. Wife is not ready to live with the in-laws in one city and is urging the husband to shift to another city. I don't want to stay with your parents. Let us move out. I find this city too cluttered. Let us just go to a metropolitan city, or let us go to a non-metropolitan city, whatever the case may be. So that in itself will not amount to cruelty. Something more needs to be proved. Another thing, wife was not able to cook and speak Hindi as what husband wanted. You should speak good Hindi. You should not speak in English or a vernacular language. You should cook good food. All of that also would not amount to cruelty. Husband going at the workplace of wife, or say wife going at the workplace of husband to inquire about her character as to how is she, has she made any sexual advances to anybody else, is she flirtatious in nature, all of that would amount to cruelty. In this case, the husband was sitting outside and in the nights also, outside the office of the wife, just to inquire as to how is she. She was doing night shifts. So Andhra Pradesh High Court said that this is cruelty. How else will that wife get defamed, or it will affect her mental well-being? Husband leaving wife without food and locking up in a house for 2 days. So again, Uttarakhand, this is Aman Panchal versus Rashmi AIR 2014, Uttarakhand 27. The court held that yes, this would amount to cruelty. So we understand as to what are the distinction between criminal law, civil law, and what is the threshold, who can be a complainant, against whom can it be filed, before which forum can it be filed, within how long can it be filed, what are the instances of cruelty under criminal law and what are not, how can one seek discharge, how can one seek quashing. Has the Supreme Court taken cognizance of the fact that this law is being misused and told the legislature to change it? Did the legislature change it? And then we looked at the cruelty under the matrimonial law, which is the marriage aspect of it. A decree on the basis of cruelty, how the court will determine what is cruelty, instances in the matrimonial law, which amounts to cruelty, which do not amount to cruelty. What is the extent of satisfaction? What are the types of cruelty, physical cruelty and mental cruelty? Now, please, if there are any questions, I'll be happy to entertain them.
Ma'am, am I audible?
Yes.
Okay, thank you, ma'am, for the enlightening presentation. Your insights into the nuances of laws surrounding cruelty have given us much to ponder. Now, before we wrap up tonight's session, we will address a few questions that were submitted by our audience beforehand. These questions have been carefully selected to further enrich our discussion. So, ma'am, surrounding the cases that we have discussed, the statistics that we have discussed, one question arises that when we hear the term cruelty, it is somehow directed towards women at large. Is this perception changing with the evolution of the laws?
As I said, in matrimonial law, in Hindu Marriage Act, even in Muslims' dissolution of marriage act, cruelty, a victim can be a husband as well as a wife. It is not necessarily a woman as given in our criminal law. So yes, times are changing. Court has taken cognizance of the fact that this law is being misused and is directing legislature to amend it. That's a different thing, that the current new laws that are being brought in have not made any change as compared to the previous ones.
Thank you, ma'am. The next question stems from the fact that at this day and age, where we see that AI is taking over, or rather, I should say, humans are trying so hard for it to take over. What is the contribution of AI and related technologies in the scope of these laws?
The concept of AI, I would say, would help in, say, drafting of these petitions. Probably advanced stages of AI. Suppose if we take ChatGPT, the advanced paid versions of ChatGPT would give us correct judgments. Or say technological aspect of it, if I see, suppose a Alexa is kept in a room and husband and wife are fighting, and that Alexa captures the entire conversation between husband and wife, and if that evidence can be used, especially with the new criminal law where electronic evidence is made as a primary evidence, and under section 63 of Bharatiya Sakshi Adhiniyam, it will be considered with that certificate, which was earlier 65B Indian Evidence Act certificate, will be considered as a primary evidence. I feel to that extent, yes, AI and technology can be used. Otherwise, earlier also WhatsApp screenshots, photographs, video recordings, CCTV camera footage, all of that can be used to prove that there is commission of cruelty. But at the same time, what I feel, there might be certain misuse also of AI and technology by, let's say, concocting, or as I said, Supreme Court recognized that there is over implicating or over usage or misuse and exaggeration of facts might also be done with the help of AI. So, which I am scared of.
Thank you, ma'am. So the next question is the fact that we designate justice as a virtue to legislature or to the judiciary, but we forget sometimes that people at large, the citizens of the country, are the first line of defense against such injustices. So the question arises: what is the least a layman could do to avoid cruelty happening around him or her?
At least what one can do to avoid such offenses happening is call up police. And especially, as I said, with the new criminal law, it is very easy to register FIR. An informant, not just a victim, can register the FIR, not actually going to the police station. Through e-FIR, online FIR, registration can take place. Of course, it is to be followed up within 3 days. The complainant has to go to the concerned police station and has to lodge the physical FIR as well, which will be mostly just acknowledgement from the police officer of the said online FIR. Or let us assume a zero FIR concept is being now recognized in the Bharatiya Nyaya Sanhita, B.L.S, which allows that irrespective of whatever jurisdiction, whichever police station is actually concerned with that offense, if suppose parties are, say, have gone on a honeymoon, say to Goa, and their cruelty is being committed, and a passerby or say a neighbor ideally should report it, because we as humans should help each other. That's morally, I believe, upright, and they wish to report it, but the party's marital home, say, is, say, in Jammu and Kashmir, or say wife's parental home, say, is in Kerala. So then, of course, they need not wait to go back to Kerala or Jammu and Kashmir. They can instantly lodge zero FIR in Goa itself. And it is the duty of the police officer then to transfer that FIR to the concerned police station. Complainant or informant need not run around for that transfer to happen, to take place.
Thank you, ma'am. The final question that is a bit deviated from the marriage aspect of cruelty and is related to the digital age. It asks, how has the digital age impacted the manifestation and prosecution of cruelty, particularly with cyberbullying and online harassment?
So, cyberbullying and online harassment, as I said, cruelty in our legislations are only focused with respect to the matrimonial matters, be it the criminal aspect of it or be it the civil aspect of it, which is, say, BNS 85, 86, 490, 80 IPC, or Section 13(1)(1)(a) of the Hindu Marriage Act, or say other personal family laws. So, cyberbullying, I don't see coming anywhere in between husband and wife. Of course, say digital age, if say husband is, say, stalking and engaging stalkers to emotionally distress the wife, then that aspect of it I can still understand. But again, the accused there would be the husband and the relatives. So, cruelty in the layman's sense done to a person by a stranger is not what the cruelty acknowledges in our legislation. That would be, say, harassment, or say criminal intimidation, or say criminal breach of trust if there is some sort of, say, hacking took place of the email ID or the personal account. So those will be the aspects. So, but not in matrimonial discord.
Thank you, ma'am, for providing such insightful perspective on these complex issues. Unfortunately, that's all the time we have for questions tonight. And with that, we conclude yet another illuminating session brought to you by Just Corpus. A big thank you to our guest speaker, Ms. Manasi Bhushan, ma'am, for sharing her expertise with us tonight. And of course, a heartfelt thank you to our viewers for tuning in. I'm Akshar Aditya, signing off for tonight. Thank you, ma'am.